Petitioners and alien beneficiaries should be aware that a family-based petition accords no immigration status, nor does it bar removal. I've been saying for several months that USCIS officers have been mentioning that when somebody files an I-130 family petition for a family member who's in the US and they entered without inspection, once a final decision has been made on that I-130, an NTA or notice to appear in immigration court to initiate removal proceedings will be generated and mailed out to that immigrant. People have asked me for a citation to this, and I don't have one. It wasn't an official policy, but multiple USCIS officers have confirmed this. Honestly, I've had several I-130s decided within the past few months, and so far none of them have received notices to appear in immigration court. So I was beginning to question whether or not this is actually real, because multiple attorneys have mentioned in the groups I'm in that USCIS officers have confirmed that this is in fact the guidance that they've been receiving from up top. Well, on August 1st, there was an official policy change to Volume 6, Part B, Chapter 5 of the Policy Manual. They added Section 3, and this section is entitled Removable Aliens, and it says, if USCIS determines the alien beneficiary is removable and amenable to removal from the United States, USCIS may issue a notice to appear, placing the beneficiary in removal proceedings. Petitioners and alien beneficiaries should be aware that a family-based petition accords no immigration status, nor does it bar removal. So there it is. It is officially beginning. The interesting word there is may. So it seems to suggest that the officers have some discretion about whether or not to place someone in removal proceedings. Ordinarily, if it was just a black and white policy guidance order, it would say shall, which doesn't give them discretion to make a decision. We'll see how that actually plays out if they end up ever exercising favorable discretion. I think it's gonna ultimately be up to the USCIS officer who conducts the interviews, since almost all I-130 applications will end up getting an interview. And the second part of that policy amendment that says an I-130 affords no benefit is absolutely true. An I-130 by itself does not get you a green card. I've done several videos on this. This is referring, by the way, to I-130 petitions filed for beneficiaries or immigrants who are within the United States. If you're outside of the United States, this doesn't apply. This is really in the context of people being in the United States. And I think it's gonna dramatically increase court backlogs if a notice to appear is gonna be filed for one of the millions of I-130 petitions that are currently pending. This is gonna be a huge problem for almost every preference category where the beneficiary is out of status in the United States. You know, the previous videos I've made and the guidance that I thought that was gonna come through was for I-130 beneficiaries who entered the US without inspection. But this seems to apply also to visa overstays, which ICE seems to be going after pretty hard right now. There were even recent reports of immigrants who had adjustment of status applications pending, like this guy in Oregon who got detained while he was driving his kid to daycare. He had an adjustment of status application pending. He entered on a student visa, and according to his attorneys, they applied for adjustment of status before the student visa expired. But he's still in a detention facility. His attorneys said that he was never unlawfully present in the US because he applied for adjustment of status before the duration of stay on the F1 visa, the student visa, expired. So in that case, he wasn't even out of status, because if you apply for adjustment of status before your visa expires, you're not even out of status. So it's gonna be interesting how this plays out. I think this policy, based on some of the wording, applies to standalone I-130s. I think you're still good if you file your I-130 with an adjustment of status application, but don't just do that. Make sure you qualify for adjustment of status. I've done a ton of videos on when you can apply for adjustment of status with an I-130. And just to recap on that, it needs to be an immediate relative petition. That is a spouse of a US citizen, the parent of a US citizen, or the child of a US citizen, and you must have entered with inspection or parole. If you entered illegally, or let's say for example, you're a US citizen, but your mom entered illegally, and you file an I-130 petition for your mom once you turn 21 years old, you're gonna end up placing your mom in removal proceedings, and she better have some defenses available from removal in the event that that happens. I just consulted with someone about this. It turns out the mom might be eligible for something called cancellation of removal, but ultimately my advice was I wouldn't file this right now. Like, let's not deal with the headache of placing your mom in removal proceedings based on the off chance that we will qualify for this defense from removal. Let's wait a couple years. Don't place your mom into unnecessary risk, unless you fully understand the risk and you just can't live the way you're living right now and you want a resolution to your immigration status and you're willing to take that risk. It really is a case-by-case determination based on how much risk you're comfortable with. As more developments come to light from this policy change, I'll be making more videos updating you guys on what you should and shouldn't be looking out for or worrying about, what's fear-mongering, what's actually happening on the ground. Like, that's kind of the purpose of this channel, to help people make decisions, informed decisions, so that they can best plan for their futures and their families. And for those of you who are new to the channel, my name is Puyan Darian. I'm an immigration attorney. I have an office in New York, but I practice immigration law nationwide. I have clients in all 50 states. If you want to consult with me about a family-based immigration matter or removal defense problem, you received a notice to appear, you don't know what to do, you have court dates scheduled, or what I love focusing on is marriage-based green card cases. We have a ton of those, and it's actually what I try to focus my entire practice on. These are cases I enjoy working on. So if you have a family-based issue, a naturalization or citizenship issue, a removal defense issue, you could schedule a consultation directly with me. My information is in the video description below, and I'll see you guys next time for another video.